and welcome back to Attorney Paz's Rants of a Criminal Defense Attorney. Today I want to talk about an interesting issue that has presented itself in a couple of my cases now, and it relates to DNA testing and the reports that come back and how the testing is done and what the reports actually mean. So the reports have changed over the years. They used to compare alleles and provide a little chart. Now they don't do that. And now what they do is they talk a lot about probabilities. It's not a yay or nay, this person's DNA is on this item. It's, it's more likely to come from this person than, other people in the community, and they'll give you a probability. Now, if the mixture is complex, which means that it's more than just one DNA. So keep in mind, if multiple people touch things, there's going to be multiple DNAs on there, multiple types of DNAs. And so depending on how complex the mixture is, they will have to determine not only the likelihood that it's 2 or 3 or 4 or 5 people on this item. And if it's more than 4 people, the mixture is going to be too complex for them to develop a DNA profile to individualize each person. So if there is a complex mixture, what they're doing is they're getting probabilities of how likely it is that it's 2 people, 3 people, 4 people, or more. And so say it's 40% likely that it's 3 people, but 20% likely that it's 4 people, and 10% likely that it's more than 4 people, they're going to pick the likelihood that's highest. So keep in mind that that is not a 50% likelihood even that it's a mixture with 2 people or a mixture of 3 people. They're just picking the highest degree of likelihood, even if it's not likely at all. And so what this is doing is it possibly is allowing evidence in at trial that isn't reliable, right? So I have a gun case like this where there were 2 firearms found. One of the firearms is too complex a mixture in order for them to make a comparison. So there's more than 4 DNAs on there, and then so they're not even going to talk about it. Now, the second gun is a very complex mixture as well. And when you read the reports, essentially what it says is they are making these assumptions about how many contributors there are. Now, the number of contributors for comparisons, or to be eligible for comparisons, there could very well be more contributors. If there are more contributors, they can't make this comparison. It is not reliable. So essentially what they are doing is making these assumptions. And so what I told the state attorney was, because of this and the reliability issue, I was going to ask for something called a Porter hearing. So what is a Porter hearing? In federal court, it's called a Daubert hearing. In state court in Connecticut, it's called a Porter hearing. Those are just the names of the cases that had the requirements to have these hearings. And essentially what it is the reliability of the scientific process that's involved so that it can be admitted at court or maybe not admitted at court. And so it's basically a separate evidentiary hearing where the people at the forensic lab are going to testify as to their processes, what these probabilities mean, the likelihood of these probabilities, and their reliability. And the judge will then make a determination based on what he hears at the trial to see if this is reliable enough to be admissible. Now, let's just take polygraphs, for example. Polygraphs went through Daubert hearings a long time ago, and polygraphs are not considered to be a reliable scientific tool to be admissible at a trial. So that's why I tell clients it's not even in your best interest to take these polygraphs, because it's not going to be admissible for you at a trial anyway, because this has already been determined by Daubert. Now, obviously, if there's a significant change in the way that lie detectors are administered, change in their scientific reliability, then you can rehab these hearings if there's a development or whatever. But, those are not allowed to be admissible in criminal trials. Now, the same thing would be true if we went through with this Porter hearing and it was determined that based on these probabilities and the assumptions that they're making about the number of contributors, this is not a reliable piece of information to be presented to the jury. So in this particular issue, this issue has not been determined in Connecticut, but there is another case in another jurisdiction in a federal court that has precluded this evidence from trials because of the lack of reliability. So it is an interesting legal issue. And so if it does go forward with a trial, what you do is you have this Porter hearing first to determine if it's admissible. If it is, then the court would be, the state attorney would be allowed to present that to the trial. If not, that may determine whether or not the state even wants to proceed with that prosecution, because if they're not allowed that piece of evidence, then it's something that they might not be able to prove their case. Hope this was interesting for you, and follow me for more.